Picture this, a packed courtroom, the air thick with tension, as a lawyer dramatically lifts a piece of evidence high above their head, only for the jury to realize it's a half-eaten sandwich sealed in a plastic bag. The judge's eyebrows shoot up, the gallery erupts in murmurs, and somewhere in the back, a bewildered spectator whispers, "Is this really happening?" Welcome to the wild, unpredictable world of American courtroom drama, where the evidence presented isn't always fingerprints or DNA samples. Sometimes it's, well, let's just say things get weird. For over 2 centuries, the US legal system has been a stage for some of the most bizarre, head-scratching, and downright hilarious evidence ever presented. From ghostly testimonies to livestock behaving as witnesses, the line between reality and absurdity blurs in ways that would make even the most seasoned lawyers question their career choices. And here's the thing, these aren't just urban legends or exaggerated tales. Each piece of evidence was seriously argued in front of a judge and jury, with real cases hinging on the strangest details imaginable. So why does this matter? Because behind every oddball exhibit is a story, a moment where the law collided with the utterly unexpected, where logic took a backseat to sheer creativity. Whether it's a parrot repeating a damning confession or a jar of homemade pickles used to prove a point, these cases reveal the human side of justice, flawed, surprising, and occasionally hilarious. Over the next few minutes, we're diving deep into the 31 weirdest pieces of evidence ever presented in US courtrooms. Some will make you laugh, others might leave you staring at the screen in disbelief, but one thing's for sure, you'll never look at a courtroom the same way again. Ready to uncover the strangest corners of legal history? Let's get started. In the late 1980s, a divorce case took a turn straight out of a horror movie when a child's doll became the star witness. The parents were locked in a bitter custody battle, and the mother's legal team made an unprecedented move. They submitted the doll itself as evidence, claiming it was possessed. Witnesses swore under oath that the toy would speak in a voice that didn't belong to the child, uttering phrases like, "I hate you," when no one was nearby. Even more chilling, some testified that the doll moved on its own, its head turning to follow people across the room. The judge, faced with an object that supposedly defied the laws of physics, had to make an impossible ruling. Was this doll admissible as evidence? Prosecutors argued the toy demonstrated a harmful environment, while the defense dismissed it as superstition or worse, a hoax. Legal scholars still debate whether the courtroom should have entertained the idea at all, but the truth is, this wasn't just about a creepy toy. It was about how far the justice system is willing to go when the unexplained enters the record. What makes this case unforgettable isn't just the absurdity, it's the lingering question of what really happened. Was the doll a product of mass hysteria, a child's overactive imagination, or something far stranger? We'll never know for sure, but one thing's certain: when the gavel came down, legal history had been made. And it wouldn't be the last time a courtroom faced the truly bizarre. In 2007, a probate court in Pennsylvania found itself staring down an item that belonged more in a Bram Stoker novel than a legal proceeding. A full vampire hunting kit, complete with wooden stakes, a mallet, vials of holy water, and even a pouch of garlic powder. The case centered around a disputed inheritance where one family member claimed the antique kit, passed down for generations, was a priceless artifact, while others dismissed it as a macabre novelty. But when the kit was officially entered into evidence, the courtroom had to grapple with a question straight out of Gothic fiction. Could an object designed to slay mythical creatures hold any legal weight? What made this kit so compelling wasn't just its eerie contents, but its backstory. Expert witnesses testified that these kits were historically produced in the 19th century, often sold to wealthy travelers venturing into Eastern Europe, where vampire folklore ran deep. The defense argued it was nothing more than a curiosity, a conversation piece with no real value beyond its creepy charm. But the prosecution brought in appraisers who insisted such kits were rare collector's items worth tens of thousands of dollars, enough to seriously impact the estate's division. The judge's dilemma, whether to treat the kit as a legitimate asset or a bizarre relic with no place in probate law. In the end, the court ruled it had monetary value as an antique, regardless of its intended purpose. But the case left everyone wondering, how many other vampire-slaying kits are sitting in attics or vaults, waiting to resurface in another legal battle? It's a reminder that in the American justice system, even the most outlandish objects can become evidence if someone's willing to stake their claim on them. And speaking of stakes, this wasn't just about money. The trial tapped into something deeper, our enduring fascination with the supernatural and how easily it can bleed into the real world. After all, if a jury can weigh the value of a vampire kit, what's next? Werewolf traps, ghost detecting equipment, the line between legend and evidence might be thinner than we think. In 1996, a New Mexico construction worker filed a workers' compensation claim that would make even the X-Files team do a double take. He wasn't just arguing about a slipped disc or a broken bone. His evidence for psychological trauma included handwritten diaries documenting multiple alien abductions. The pages described bright lights, medical experiments by gray-skinned beings, and missing time he couldn't explain. His legal team argued these experiences left him too distressed to work, presenting the journals as proof of legitimate mental anguish. The courtroom reaction, somewhere between skepticism and stunned silence. Opposing attorneys scoffed, calling it science fiction, not evidence. But the worker's psychologist testified that his accounts were consistent with other abduction survivors. Whether real or perceived, the trauma was genuine. This forced the judge into uncharted territory. Could personal accounts of extraterrestrial encounters hold up in a legal proceeding? Unlike a disputed contract or a traffic violation, this case hinged on something far more subjective: the intersection of belief, memory, and the law. What makes this case fascinating isn't just the surreal premise, but the precedent it flirted with. If a diary about aliens could be admitted as evidence of mental harm, where do courts draw the line? Could someone claim PTSD from a werewolf attack or time travel? Legal experts still cite this case when debating how to handle unconventional claims. The judge ultimately ruled that the diaries couldn't prove physical workplace injuries, but refused to outright dismiss the psychological impact, leaving the door cracked just enough for future cases to nudge it open further. And here's the kicker: this wasn't an isolated incident. Across the country, other plaintiffs have tried presenting everything from Bigfoot sightings to demonic possession as evidence. While most get dismissed, this case stands out because it forced the legal system to confront an uncomfortable truth. Sometimes the most compelling evidence isn't about what's provable, but what someone truly believes happened to them. Whether you buy into UFOs or not, the workers' diaries became a mirror held up to justice itself, reflecting how messy and human the search for truth can be. In 2014, a landlord-tenant dispute in Michigan took a turn straight out of The Walking Dead when eviction papers landed next to an unusual piece of evidence: a detailed, hand-drawn blueprint titled "Zombie Apocalypse Survival Plan." The landlord claimed the tenant was unstable, citing the elaborate diagrams of barricades, weapon stashes, and escape routes scribbled across the pages as proof. But the tenant fired back, arguing his apocalyptic preparations were just a creative hobby, no different than someone sketching fantasy maps or drafting sci-fi stories. The courtroom became a battleground over one question: when does imagination cross the line into legitimate concern? What made this case so surreal wasn't just the zombie theme, it was the level of detail. The plans included precise measurements for reinforcing doors, lists of canned food stockpiles, and even a designated safe room with a hand crank radio. Psychological experts were called in, with one testifying that hyper-specific disaster prep could indicate anxiety disorders, while another countered that pop culture obsessions don't equate to mental illness. The judge faced a dilemma familiar to anyone who's binge-watched doomsday prepper shows. Where do you draw the line between harmless enthusiasm and red flag behavior? Legal analysts later pointed out the irony. The tenant's paranoia about societal collapse became a self-fulfilling prophecy when his own documents were used against him. The ruling ultimately sided with the landlord, but the case sparked debates far beyond that courtroom. Could a Dungeons & Dragons campaign notes be next? What about alien invasion fan fiction? In an era where prepping for disasters, real or fictional, has gone mainstream, this trial highlighted how easily personal quirks can be weaponized in legal fights. And it left viewers wondering, if the zombie apocalypse ever does hit, at least one guy in Michigan would have been ready. Too bad his preparedness got him evicted first. The real twist: after the trial, the tenant's zombie plans went viral online, with survivalist forums praising his strategies. Some even called him a visionary. So while the court saw instability, a subculture saw genius, proving that in the eyes of the law, context is everything. And sometimes the weirdest evidence isn't about proving facts at all, but about who gets to define what's normal. The year was 1978, and a small-town courthouse in Ohio became the unlikely stage for a battle over something most judges never expect to see on their docket: a 200-year-old urn that allegedly whispered to its owners. The dispute began when a wealthy eccentric passed away, leaving behind a will that specifically warned his heirs about the artifact's malevolent energy. One relative refused to take it, calling it cursed, while another scoffed at the superstition until strange things started happening. Pets would hiss at the urn without provocation. Family members reported nightmares after being near it, and one cousin even claimed the lid moved on its own. When the case landed in probate court, the urn wasn't just part of the estate, it was the case. Prosecutors brought in paranormal investigators who testified under oath that the urn emitted abnormal energy fields, while an antiques appraiser argued it was simply a rare Qing Dynasty piece worth a fortune. The courtroom drama reached its peak when a historian revealed the urn's backstory. It was supposedly looted from a Chinese tomb in the 1800s, with local legends claiming it held the spirit of a wronged nobleman. Suddenly, the legal debate wasn't just about inheritance law. It was about whether an object's eerie reputation could diminish its monetary value. Could a jury really put a price tag on something that might be haunted? The judge's ruling was as pragmatic as it was surreal. He acknowledged the urn's unsettling reputation, but refused to deem it legally cursed, assigning it a fair market value while allowing the reluctant heir to officially renounce their claim. What makes this case unforgettable isn't the verdict, though, it's the ripple effect it created. Paranormal researchers still cite it as precedent for how courts handle haunted objects, and antiques dealers now joke about adding "no ghosts included" disclaimers to their paperwork. Most importantly, it proved that in the eyes of the law, even the supernatural has to play by mortal rules, whether the spirits like it or not. And here's the twist: after the trial, the urn sold at auction for 3 times its appraised value. Turns out some collectors will pay extra for a good ghost story. The real curse: knowing you could have owned a piece of history if you were brave enough to take it home. But this wasn't just about a spooky heirloom. It exposed a deeper tension in our legal system. How do you weigh tangible evidence against intangible fear? The urn forced everyone, judges, experts, even the bailiff, to confront the uncomfortable truth that some things defy logic yet still shape our decisions. And in that courtroom, for a few surreal hours, the line between folklore and fact blurred into something even stranger: a legal precedent. In 2003, a Washington state courtroom became ground zero for one of the most unconventional environmental battles in history, all thanks to a Ziploc baggie filled with coarse, dark brown hair. A coalition of conservationists had sued a logging company to block clear cutting in a remote stretch of forest, claiming the area was critical habitat for an endangered species. But this wasn't about protecting owls or spotted frogs. Their star evidence, clumps of fur they insisted belonged to none other than Bigfoot. The legal team's argument hinged on a creative interpretation of environmental law. If the hair could be linked to an undiscovered primate, they reasoned, the forest might qualify for protection under endangered species statutes. They'd gathered the samples from tree branches and makeshift nests deep in the woods, even presenting plaster casts of massive footprints alongside blurry trail cam footage. Experts testified about the hair's unknown primate origin, noting its unusual thickness and DNA inconsistencies with known local wildlife. The courtroom buzzed as biologists debated whether science had room for legends, while the logging company's lawyers dismissed it all as roadside attraction gimmickry. What made this case extraordinary wasn't just the audacity of using cryptozoology in a federal lawsuit. It was the deeper question it forced the judge to confront. How does the law handle what science hasn't yet proven? The conservationists weren't arguing that Bigfoot definitely existed. They were arguing that potential existence warranted caution, a better safe than sorry approach to habitat preservation. The defense shot back with chilling pragmatism. If courts protected every patch of woods where someone claimed to see monsters, industry would grind to a halt. In the end, the judge ruled the hair samples inconclusive, but the case left an indelible mark. Legal journals still reference it when debating the burden of proof in environmental cases, and wildlife agencies now quietly train rangers on how to document, but not endorse reports of anomalous creatures. Meanwhile, the submitted hair vanished from evidence storage under mysterious circumstances, fueling rumors it was too hot to handle. Whether it was Sasquatch, a mangy bear, or an elaborate hoax, one thing's certain: that courtroom became the only place in America where Bigfoot was, however briefly, a matter of legal record. The real legacy of this case, it blurred the line between myth and environmental policy in ways that still echo today. After all, if a creature might be out there, shouldn't we err on the side of protecting its home? Or does the law demand cold, hard facts even when the truth is still lurking somewhere in the shadows of the woods? For a few surreal days in that courtroom, even the gavel seemed to hesitate, caught between what we know, what we believe, and what we're afraid to admit could be real. The year was 2011, and a Florida courtroom found itself staring at a series of elaborate, color-coded maps that looked like they'd been ripped from a sci-fi blockbuster. Floating skyscrapers, holographic highways, and districts labeled Quantum Commerce Zone. The defendant, a self-proclaimed chrono-entrepreneur, had used these blueprints as collateral to secure millions in investor funds, claiming they were accurate renderings of New York City in the year 2150. His pitch was equal parts dazzling and absurd. He'd visited the future, he insisted, and these maps were his proof. Investors desperate to get ahead of the next big thing poured cash into his venture, only to realize too late that the only thing getting transported was their money straight into his offshore accounts. What made this case remarkable wasn't just the brazenness of the scam, but the sheer effort behind the ruse. The maps weren't crude doodles, they were professionally printed, annotated with futuristic jargon like anti-gravity transit hubs and neural net shopping districts, complete with tiny copyright symbols as if they'd been smuggled back from a corporate archive. Expert witnesses for the prosecution tore them apart, pointing out that the future skyline suspiciously resembled downtown Tokyo with Photoshop filters, while the defendant's own time travel device turned out to be a gutted microwave wired to a car battery. Yet during cross-examination, he remained eerily composed, doubling down on his story with such conviction that even the bailiffs exchanged glances. "You'll see," he told the jury. "When the cities rise, you'll remember me." The trial hinged on a question as old as snake oil salesmen. Can pure spectacle override common sense? investors testified they'd been swayed by the map's authentic wear, frayed edges and coffee stains artfully added to suggest age. One even admitted he'd been shown a prototype time machine that emitted sparks and beeped, though he'd later realized it was a repurposed pinball machine. The defense, meanwhile, pivoted to an unexpected argument. Even if the defendant believed his own delusion, did that constitute fraud? Psychologists debated whether he was a con artist or a true believer, while the judge wrestled with whether to treat the maps as evidence of deception or performance art. The verdict was swift, guilty on all counts, but the legacy of those maps lingers in legal circles, cited in cases where charisma collides with credulity. It's a cautionary tale about the seductive power of detail, how a splash of technobabble and a splashy visual can make even the impossible feel inevitable. And for the investors left holding stacks of worthless futuristic blueprints, the only time travel they experienced was the agonizing journey back to their emptied bank accounts. The real kicker, after the trial, the maps sold at auction as outsider art, fetching 5 figures from collectors who appreciated their unintended irony. Turns out the defendant was right about one thing: his vision of the future did turn a profit, just not in the way he'd promised. In 1992, a California judge made legal history by allowing something unprecedented into a missing persons case: a grainy VHS tape featuring a self-proclaimed psychic's dramatic reenactment of her visions. The footage showed the woman wandering through a forest, gasping at invisible clues, and even miming the discovery of a body near a cluster of oak trees. The prosecutor argued the tape wasn't being presented as fact, but as an investigative roadmap, a creative way to spur new leads in a cold case. The defense, meanwhile, called it televised guesswork, a slippery slope that could open the floodgates to all manner of unverified supernatural claims. What made this moment so pivotal wasn't just the surreal sight of a jury watching psychic theatrics on a courtroom TV. It was the prosecution's strategic framing. They'd carefully avoided calling the psychic a witness or her visions evidence. Instead, they positioned the tape as a catalyst, a spark to reignite a stalled investigation. And bizarrely, it worked. The psychic's ramblings about a water-stained backpack and a broken wristwatch matched details the police had never released publicly. Detectives later admitted off the record that her tape led them to search a previously overlooked ravine. Though no body was found, the legal community erupted. If a psychic's hunches could steer official investigations, did that mean the justice system was dabbling in the occult? Critics warned of the precedent. If visions on tape were admissible, what about dreams scrawled in a diary, or children's imaginary friends describing crimes? But supporters countered that detectives routinely follow far flimsier tips: anonymous phone calls, jailhouse snitches, even hunches from patrol officers. At least the psychic's tape was recorded before the fact, they argued, making it harder to fabricate after the case unfolded. The judge's compromise was a masterclass in legal threading the needle. The tape stayed in, but with strict instructions that jurors treat it as investigative context, not proof. The case's legacy is murkier than the psychic's VHS static. While no missing person was found, the investigation's sudden revival did pressure a suspect into fleeing the state, a move that later helped convict him on unrelated charges. Legal scholars still debate whether the tape crossed a line or merely exposed the messy reality of how cases get solved. After all, if a jury can weigh bloody knives and fiber evidence, why not a trembling voice on tape describing a shadow near the rocks? The answer, it turns out, depends less on what's in the video and more on what the law dares to acknowledge as possible. And here's the twist: years later, a retired detective confessed the psychic had been fed those uncannily accurate details by an overeager rookie, a fact buried to avoid embarrassing the department. The tape wasn't prophecy, it was a self-fulfilling prophecy. Yet the legal door it cracked open remains ajar, a reminder that in the hunt for truth, even the justice system can get tempted by the glow of the unexplainable. Whether that's progress or desperation depends on who you ask, but one thing's certain: no psychic has ever been sworn in as an expert witness since. Maybe the courts finally learned to trust the living over the gifted. Or maybe they're just waiting for the next tape to roll. In 1985, a Montana courtroom was handed a set of photographs so bizarre they might as well have been lifted from a low-budget horror film. The defendant, a ranch hand accused of assaulting a neighbor during a blizzard, insisted he wasn't responsible for the violence because the real culprit, he claimed, was the full moon. His evidence, a series of Polaroids showing what appeared to be a hunched, fur-covered figure mid-transformation, its face contorted between human and something distinctly canine. The images were grainy, darkened by shadows, but the implication was unmistakable. This man was arguing he'd temporarily become a werewolf and therefore couldn't be held accountable for his actions. Prosecutors dismissed the photos as either a hoax or the result of extreme intoxication, pointing out the defendant's history of bar fights and erratic behavior. But his public defender took a different tack, calling in a folklorist who testified that lycanthropy beliefs dated back centuries, with documented cases of people genuinely believing they shape-shifted under lunar cycles. The courtroom erupted when a psychologist suggested the defendant might suffer from clinical lycanthropy, a rare delusion where patients believe they transform into animals. Suddenly, the debate wasn't just about blurry pictures, it was about whether a centuries-old myth could hold weight in a modern legal system. The judge's dilemma was unprecedented. If he allowed the photos as evidence, would he be validating supernatural claims? But if he dismissed them outright, could he ignore the possibility of mental illness? In the end, the photos were admitted not as proof of werewolves, but as potential insight into the defendant's state of mind. The jury, however, wasn't convinced. They convicted him, though the sentencing phase included mandatory psychiatric evaluation. What makes this case unforgettable isn't just the audacity of the defense, but the questions it left dangling. How does the law handle defendants who genuinely believe, or pretend to believe, in the impossible? And where's the line between cultural folklore and legal strategy? Years later, the photos resurfaced in an auction, accompanied by a sheriff's note joking that the department kept garlic and silver bullets in evidence storage, just in case. A playful nod, perhaps, but beneath it lurks a truth every courtroom occasionally faces. Sometimes the strangest evidence isn't about what's real, but what someone desperately needs the law to believe. In 2006, a Missouri courtroom fell silent as jurors leaned forward to hear the crackling audio clip that had everyone questioning the boundaries between evidence and the afterlife. The case involved a wrongful death lawsuit filed by the family of a construction worker who'd collapsed on the job, claiming unsafe conditions led to his fatal heart attack. But the defense team had an ace up their sleeve, or more accurately, on their cassette tape. They played a series of eerie recordings they insisted captured the man's voice after his death, whispering phrases like "let go" and "my time" through the static. These weren't just random noises, they were electronic voice phenomena, or EVP, snippets of sound paranormal investigators claim are messages from beyond the grave. The legal strategy was as bold as it was unorthodox. The defense argued these recordings proved the deceased had accepted his fate, absolving the company of responsibility. A sound engineer testified that the audio contained distinct syllables matching the man's speech patterns, while a self-styled paranormal expert swore the clips couldn't be explained by interference or pareidolia, the brain's tendency to find meaning in random noise. The prosecution, meanwhile, called it a desperate stunt, pointing out that EVPs had never been admitted in a U.S. court before. "You might as well submit a Ouija board," one lawyer scoffed. But the judge, after hours of deliberation, allowed the recordings as evidence, not as proof of an afterlife, but as a controversial window into the family's emotional state. What followed was a surreal collision of spirituality and jurisprudence. The jury heard hours of white noise punctuated by faint, disembodied whispers, while psychologists debated whether grief could make families hear what they needed to hear. The defense's gamble backfired, though instead of providing closure, the recordings left the courtroom unsettled. One juror later admitted the experience felt like being trapped in a horror movie, while another confessed they'd slept with the lights on for weeks. The case's legacy is as haunting as the tapes themselves. While the family ultimately won their lawsuit, the precedent set by those EVPs lingered. Legal blogs still debate whether courts should entertain the unexplained, especially when it tugs at emotions rather than facts. And for paranormal researchers, the trial became a rallying cry. If ghostly whispers could echo in a courtroom, maybe the legal system was finally ready to listen. But here's the twist. Years later, an audio forensics team reanalyzed the recordings and found the voice was likely a radio bleed over of a late-night country music DJ. The so-called message from beyond, just the tail end of a Willie Nelson lyric. Yet the question remains, in the search for truth, does the law have room for what we want to believe, even when the evidence dissolves into static? That Missouri courtroom learned the hard way that sometimes the most compelling proof isn't what you hear, but what you're desperate to hear between the lines. And when justice hangs in the balance, even the faintest whisper can sound like a verdict. The dashboard camera footage showed it all, headlights flickering like strobes, the radio scanning through stations at impossible speeds, and the steering wheel jerking violently left and right with no one touching it. This wasn't a scene from The Exorcist. It was exhibit A in a 1999 lemon law lawsuit that turned a Pennsylvania auto dealership showroom into the setting for a paranormal procedural. The plaintiff, a construction foreman named Ray, had purchased what he thought was a reliable used pickup, only to discover his new wheels came with what he called a very pissed-off passenger. Ray's evidence was as unconventional as it was unnerving. Over months of ownership, he'd captured hours of footage showing the truck behaving like it had a mind of its own. Doors locking and unlocking in sequence, the gas gauge plummeting to empty moments after filling the tank, and eerie knocks resonating from the undercarriage during late-night drives. Mechanics found no electrical faults, and dealership technicians threw up their hands after the third inspection. But the clincher came when Ray's pastor agreed to testify, describing how the truck's cab temperature would drop suddenly, accompanied by the scent of sulfur, an anecdote that made even the stenographer stop typing mid-sentence. The legal battle hinged on a deliciously absurd question. Could a vehicle be deemed defective if its malfunction seemed supernatural? Lemon laws typically cover faulty transmissions or dead batteries, not haunted Chevys. The defense argued Ray was fabricating the phenomena until the judge himself reviewed the footage and noted the timestamps couldn't be faked without sophisticated editing equipment, which Ray demonstrably didn't own. Suddenly, the courtroom wasn't just debating warranties, it was wrestling with whether the law could acknowledge forces beyond its textbooks. What makes this case legendary isn't just the spectacle, it's the creative compromise the judge reached. Ruling that the truck was indeed unfit for its intended purpose, with a wry note that the intended purpose clearly didn't include paranormal containment. He ordered the dealership to refund Ray in full. But here's the twist, the truck wasn't crushed or sold. Instead, it became a macabre celebrity, touring paranormal conventions with a new owner who wanted a ghostly co-pilot. The real kicker, years later, a retired dealership mechanic confessed they'd once used the truck to smuggle bootleg electronics, and suspected a hidden, short-circuiting transponder was behind the possession. But by then, the legend had outrun the truth. After all, in American courtrooms, sometimes the strangest evidence isn't about what's broken, but what can't be explained away. The year was 2008, and a Nevada courtroom became the stage for a medical malpractice suit that read like deleted scenes from the X-Files. The plaintiff, a former Air Force mechanic named Daniel, claimed that after a camping trip in the Mojave Desert, he'd begun experiencing strange pains in his left leg. Doctors dismissed it as nerve damage until an X-ray revealed two tiny, cylindrical objects lodged near his femur. They were too perfectly shaped to be bone fragments, too dense to be surgical implants, and according to Daniel, they hadn't been there before his trip. His lawsuit didn't just accuse the hospital of misdiagnosis. It alleged they'd ignored evidence that he'd been implanted with non-terrestrial technology. And with that, a stack of grainy X-rays became the most controversial evidence in the room. What made these images so compelling wasn't just their mystery, it was the credentialed experts willing to vouch for their strangeness. A retired nurse, a metallurgist, testified that the object's composition defied known medical alloys, with a molecular structure resembling cold welded metals not typically produced on Earth. Meanwhile, the defense brought in radiologists who argued the anomalies were likely fragments from an old injury or even industrial contamination common in factory workers, which Daniel had been. But then came the clincher. A declassified military report from the 1960s entered into evidence describing similar objects found in alleged UFO whistleblowers. Suddenly, the case wasn't just about one man's leg. It was about whether the courtroom could entertain the idea that some medical mysteries might be extraterrestrial. The legal battle hinged on a question straight out of sci-fi. Can you sue for malpractice if the correct diagnosis requires acknowledging alien life? Daniel's legal team cleverly sidestepped the UFO debate by focusing on the hospital's failure to investigate any foreign object, regardless of origin. Whether it's shrapnel or a satellite part, they had a duty to remove it, argued his attorney. The defense fired back with pragmatism. Hospitals aren't equipped to handle speculative cosmology. The judge, caught between precedent and the unprecedented, ruled the X-rays admissible but with strict instructions to the jury. They were only evaluating whether the hospital had met standard care, not whether the objects were alien. The trial's legacy lives on in medical and legal circles. While Daniel lost his suit, the case sparked real-world repercussions. A handful of surgeons now quietly document unexplained implants, and a UCLA study later found similar objects in several patients, eventually linking them to Cold War-era industrial accidents. But for UFO researchers, those X-rays remain holy grails, physical proof that the truth isn't just out there, but might be lurking under someone's skin. And for the legal system, the case proved that even when evidence feels ripped from a conspiracy thriller, courts will still demand earthly answers. After all, in the eyes of the law, the burden of proof doesn't disappear even when the proof might be otherworldly. The twist: years later, Daniel's implants were removed by a private surgeon who refused to release them for testing, citing patient privacy. The objects vanished into rumor, leaving behind only those eerie X-rays and a courtroom transcript that reads like a Hollywood pitch. But the bigger question lingers. If a patient walks into an ER with something truly unexplainable, how far will medicine and the law go to solve it? Sometimes the strangest evidence isn't about what we can prove, but what we're forced to consider when the ordinary explanations run out. It started with a whispered rumor in a small Vermont town. A local school teacher, the gossip went, had been slipping handwritten curses into her neighbors' mailboxes. But what might have stayed small-town drama turned into a legal spectacle when one recipient sued for defamation in 1972. Armed with the most unusual exhibit a courtroom had ever seen, a leather-bound notebook filled with meticulously penned hexes. The plaintiff claimed each page contained spells targeting her family, from petty jinxes, "May your roses wither," to shockingly specific maledictions, "May his heart forget how to beat." The defense didn't deny the book existed, it belonged to the defendant, after all, but argued passionately that magic wasn't real, and therefore the words couldn't constitute actual harm. What made this case extraordinary wasn't just the surreal sight of a judge squinting at archaic phrases like "by the light of the waning moon." it was the legal tightrope walked by both sides. The plaintiff's lawyer, a folksy septuagenarian with a flair for theatrics, called in folklorists to testify that even if the spells didn't work, their intent could inflict psychological distress. You don't have to believe in witches to feel terrorized by one, he argued, holding up a page where the defendant had sketched a crude coffin next to the plaintiff's initials. Meanwhile, the defense countersued for religious discrimination, alleging the defendant was a practicing pagan whose spellbook was no different than a Christian's prayer journal protected spiritual expression. The courtroom became a battleground between modern law and ancient superstition, with the jury forced to weigh whether words could be weapons if both parties disagreed on their power. The trial's turning point came when a psychiatrist took the stand, revealing that the plaintiff had indeed suffered panic attacks and insomnia after discovering the book. But here's the catch. He also noted that the defendant had a history of obsessive-compulsive disorder, and her spells were likely ritualistic coping mechanisms, not genuine attempts at malice. Suddenly, the case wasn't about magic at all, it was about mental health, free speech, and how the law interprets intent when cultural beliefs collide. The judge's ruling split the difference. The defendant was cleared of defamation, but ordered to attend counseling and keep her spellbook private to avoid further, unnecessary alarm. Decades later, legal scholars still debate the implications. Could a voodoo doll submitted as evidence cause someone to lose custody? Would a satanic prayer recited near a playground constitute harassment? This case proved that in American courtrooms, the line between fantasy and liability isn't always clear, especially when the evidence reads like something out of Macbeth. And as for the spellbook, it vanished after the trial, though locals swear the defendant's garden grew unnaturally lush that spring. Coincidence, maybe. But in the eyes of the law, that's all it ever needed to be. The divorce filing would have been just another bitter legal battle until the husband claimed the paperwork itself was hexed. In 2016, a Florida man petitioning to end his marriage submitted an affidavit. It's so bizarre it made the courthouse staff do double takes. Alongside the usual allegations of irreconcilable differences, he insisted his wife's family had laced the divorce decree with a Haitian voodoo curse designed to inflict financial ruin and chronic illness upon anyone who signed it. His proof, a series of unexplained rashes that appeared after he drafted the papers, a sudden foreclosure notice on his home, and most chillingly, a sworn statement from a local Haungan, a voodoo priest who examined the document and declared it heavy with malice. What turned this from personal paranoia into a legal spectacle was the husband's audacious request. He demanded the court nullify the original filing and provide a new, spiritually cleansed document before he'd proceed. The judge, accustomed to custody disputes and asset splits, now found herself presiding over a case that felt more like an exorcism. Prosecutors dismissed the curse claims as theatrical stalling tactics, but the defense called witnesses who testified to the wife's family's deep ties to Haitian voodoo traditions. One relative even admitted under oath that the grandmother had blessed the marriage certificate years earlier, a detail that took on new, ominous meaning in light of the allegations. The courtroom's tension peaked when the Haungan took the stand, holding up the decree to the light and pointing to barely visible symbols drawn in what he claimed was ritual powder along the margins. "This isn't just paper," he told the jury, "it's a wanga, a trap." The prosecution's rebuttal was equal parts logic and sarcasm. If curses worked, wouldn't every divorce attorney in America be out of business? Yet the judge, perhaps wary of cultural insensitivity, allowed the testimony to stand, not as evidence of supernatural interference, but as insight into the husband's genuine fear and its impact on his ability to participate fairly in the proceedings. In the end, the court's solution was a masterstroke of pragmatism. They issued a fresh set of documents, ceremonially stamped by the clerk in open court, a symbolic reset that satisfied the husband's demands without officially acknowledging the curse's existence. The wife's legal team rolled their eyes but complied, eager to move past what they called superstitious nonsense. Yet years later, courthouse staff still whisper about the case, especially when printers jam inexplicably during high-stakes divorces. The real takeaway: this wasn't just about one man's fear of magic. It exposed how deeply cultural beliefs can infiltrate the legal system, forcing courts to navigate traditions they're unequipped to evaluate. When a decree is more than just ink and paper, when it carries the weight of someone's deepest fears, the law has to decide whether to dismiss those fears or find a way to work around them. And sometimes the simplest solution is to just get a fresh piece of paper and maybe keep some holy water handy at the clerk's desk. The shipping company never expected their insurance claim to hinge on whether mermaids were real, but that's exactly what happened when a 2005 maritime lawsuit took a turn straight out of a sailor's tall tale. The dispute began when a cargo vessel mysteriously sank off the Florida Keys, with the crew blaming unidentified marine activity for the damage, their evidence. A bizarre, half-decayed mermaid skeleton they'd allegedly hauled up in their nets days before the sinking, now carefully sealed in a glass case and presented to the court like something from a Victorian sideshow. The specimen was a grotesque mashup of fish and primate bones, its jaw permanently frozen in a silent scream, its delicate hands curled as if reaching for the surface. The crew's lawyer argued it wasn't just a prop. It was proof that unknown creatures lurked in those waters, potentially aggressive enough to damage ships. Marine biologists called to the stand barely contained their eye rolls, pointing out the obvious. The skeleton was a crude Frankenstein job, likely monkey bones stitched to a fishtail with wire and glue. But the defense had a wild-card witness, a retired naval officer who swore he'd seen similar creatures during classified sonar sweeps in the 1980s. "The ocean's 95% unexplored," he intoned. "You really think we've found everything down there?" What made this case unforgettable wasn't just the spectacle of grown adults debating mermaids under oath. It was the legal tightrope the judge had to walk between maritime precedent and outright myth. Admiralty law is notoriously broad when it comes to acts of God or unknown perils of the sea, but was a homemade hoax enough to trigger those clauses? The shipping company's case collapsed when an X-ray revealed modern stitching in the specimen's spine, but not before the trial exposed a fascinating truth. The law sometimes has to entertain the impossible, if only to definitively rule it out. The real kicker: after the verdict, the mermaid vanished from evidence storage rumored to have been quietly purchased by a collector who didn't care if it was fake, only that it had briefly fooled a federal court. And somewhere in the legal archives, there's still a transcript where the words "mermaid-related damages" appear entirely without irony. Because in American courtrooms, even the wildest evidence gets its day before being tossed back into the sea of disbelief. The year was 1990, and a Colorado courtroom found itself staring at a leather-bound journal that looked more like a prophet's ledger than a piece of legal evidence. The case involved a bitter contract dispute between two business partners, one of whom claimed the other had sabotaged their venture based on detailed psychic premonitions logged months before the collapse. The plaintiff, a self-described clairvoyant, had meticulously documented her visions in the journal, including eerily specific warnings about a betrayal from the man in the blue tie and financial ruin looming after the first snowfall. What began as a simple breach of contract case suddenly morphed into a surreal debate over whether foreseeability could include, well, actual foresight. The defense scoffed, calling the journal delusional fan fiction, but the plaintiff's legal team took a cunning approach. They didn't argue that the predictions were supernatural. They framed them as evidence of the defendant's long-standing intent to defraud. Whether these entries were divine insight or just gut instinct, her lawyer argued, they prove she sensed his dishonesty long before the paper trail did. To drive the point home, they highlighted entries where the plaintiff had verbatim described contract clauses the defendant later altered, dated weeks before the changes occurred. Even the judge leaned forward, thumbing through pages where looping handwriting foretold warehouse inventory disappearing like smoke, an accusation later corroborated by theft records. What made this case extraordinary wasn't just the novelty of admitting psychic logs into evidence, it was how the legal system contorted to accommodate them. The defense's economist expert unwittingly bolstered the plaintiff's case when he admitted under cross-examination that many CEO decisions rely on intangibles like hunches. Suddenly, the journal wasn't a mystic's ramblings, it was a businesswoman's gut instinct documented with unusual fervor. The prosecution even dredged up precedent cases where diaries had been used to establish state of mind, cleverly avoiding the psychic label altogether. The origin of her suspicion doesn't matter, her attorney stressed. The fact that she documented it before it happened does. The jury's verdict split the difference. They awarded the plaintiff damages for breach of contract but pointedly ignored the journal's supernatural implications. Yet the trial's legacy lingers in corporate law circles, where attorneys now advise clients to keep decision logs to preempt future disputes. As for that leather-bound journal, it vanished after the trial, though rumor has it the plaintiff later sold it as a pre-crime artifact to a private collector. Whether those pages held real prophecy or just shrewd observation, one thing's certain: in the eyes of the law, timing is everything. And sometimes the most compelling evidence isn't what you see, but when you saw it coming. The legal battle began like any other contentious custody dispute until the mother's attorney dropped a 300-page bombshell on the defense table. The document, meticulously typed and bound, wasn't just a parenting plan or psychological evaluation. It was a verbatim transcript of what the mother swore was a months-long demonic possession of her 6-year-old son. Every chilling line read like a scene from The Exorcist, guttural growls in languages no child could know, furniture levitating on command, and a voice that wasn't the boy's hissing threats like, "I'll peel his skin while you watch." The mother's legal team argued this wasn't just spectral theatrics, it was evidence of an unfit home, claiming the father's occult dabbling had invited the entity in the first place. What made this case so unprecedented wasn't just the sheer volume of the transcript, it was the forensic detail. Pages were time-stamped, witnesses' signatures lined the margins, and a Catholic priest had notarized sections where the entity allegedly revealed intimate family secrets no child could have known. The defense countered with child psychologists who dismissed it as dissociative episodes or covert coaching, but the prosecution had a trump card: audio tapes. In one clip played for a stunned courtroom, the boy's voice switches mid-sentence from a lisping first grader to a gravelly snarl demanding, "Burn the Bible or I'll snap his spine." Even the court reporter stopped typing to grip her chair. The judge's dilemma was historic. Could a transcript, no matter how harrowing, prove supernatural endangerment? Legal scholars weighed in, noting that courts had admitted everything from PTSD nightmares to psychic premonitions as context, but never as direct causation. The defense seized on this, arguing that if demonic possession wasn't recognized by the DSM, it couldn't be grounds for custody revocation. But the mother's team pivoted brilliantly. They weren't asking the court to validate exorcism, only to acknowledge that the child's belief in these events and the father's alleged role in them created psychological trauma. Then came the curveball. A court-appointed therapist revealed the boy had drawn identical demon sketches in sessions without seeing the transcript. The sketches matched descriptions of a horned figure the transcript called the Traveler. Suddenly, the debate wasn't about theology but consistency. Whether the entity was real or imagined, the child's terror was. In the end, the judge awarded the mother primary custody, citing the father's failure to provide a stabilizing environment, though the ruling carefully avoided any mention of demons. The transcript itself was sealed, but its legacy lives on. It's cited in custody trainings as a cautionary tale about how far parents will go to prove harm, and in paranormal circles as one of the few legal documents to ever skirt the supernatural. But the most haunting question remains: if a child's unwavering belief in monsters can sway a courtroom, what does that say about the power of fear and the lengths we'll go to protect them from it, whether the threat is real or written in 300 pages of hellish dialogue? The security camera footage was blurry, shaky, and barely 15 seconds long, but in 2013, it became the centerpiece of a trespassing case that turned an Oregon timber company's lawsuit into a cryptozoological circus. The plaintiffs claimed their nighttime cameras had captured a prowler dressed in a fur suit vandalizing equipment. The defendant, a local Bigfoot researcher with a history of expeditions on disputed land, countered with an argument straight out of the legend of Boggy Creek that wasn't a person in costume. It was an actual Sasquatch, meaning no human could be held liable for the damages. And with that, a pixelated shadow lumbering through the trees became exhibit A in one of the strangest property disputes in American legal history. What set this case apart wasn't just the audacity of the defense. It was the eerie specificity of the time-stamped footage. At exactly 2:17 a.m., a hulking figure crossed the infrared frame, pausing to swipe at a motion sensor before vanishing into the underbrush. The researchers' legal team hired a Hollywood special effects artist to testify that no known suit could replicate the creature's uneven gait or the way its shoulder muscles moved beneath the fur. Meanwhile, the timber company brought in a primatologist who dismantled the argument point by point, noting that the figure's proportions were all wrong for an undiscovered ape, unless Bigfoot had suddenly evolved to wear size 14 boots. The courtroom's turning point came when the judge allowed the jury to view the footage frame by frame. Zoomed in, the creature's left hand became visible gripping what looked suspiciously like a can of spray paint. The defense pivoted faster than a cryptid dodging a flashlight beam, suggesting Sasquatch might have borrowed the can from a human vandal, but the damage was done. The jury took just 40 minutes to rule in favor of the timber company, though the foreman later admitted some members had debated whether to add a cheeky footnote about potential cryptid involvement. Legal analysts still cite this case as a masterclass in how not to structure a defense. Yet it also exposed an intriguing loophole. If someone had proven the figure was non-human, who or what would have been held responsible? Wildlife statutes don't cover mythical beings, and no insurance policy lists Sasquatch rampage under Act of God clauses. The researchers' failed gamble left one lasting question echoing through the legal wilderness. When your star witness might not even exist, maybe stick to human defendants. Unless, of course, Bigfoot wants to take the stand himself. The footage itself faded into obscurity, though it still surfaces in Bigfoot forums every few years, debated, enhanced, and dissected by believers who swear the spray paint was just a trick of the light. But for one surreal week in an Oregon courthouse, the line between myth and misdemeanor got so thin, even the bailiff started glancing nervously at the woods on his lunch break. And that's the real lesson here. The law might not recognize monsters, but it definitely notices when they, or someone in a very convincing costume, start tampering with private property. The courtroom fell silent as the prosecutor held up a set of eerily precise dental molds, not to match a suspect's teeth, but to prove something far more unsettling. In a 2007 assault trial that felt ripped from a Gothic novel, a Florida woman claimed her attacker wasn't just a violent stranger but a vampire. Her evidence, a series of deep, symmetrical puncture wounds on her neck that, according to her, bore the unmistakable hallmarks of non-human dentition. The molds, crafted from forensic impressions of the injuries, showed two needle-thin incisors flanked by curved canines, a pattern no dentist had ever seen in a medical textbook. What made this case so bizarre wasn't just the vampiric angle, it was the rigor with which the legal system treated it. The prosecution didn't argue that real vampires existed. Instead, they framed the molds as proof of a uniquely dangerous weapon. Whether the defendant believes he's a creature of the night is irrelevant, the attorney stressed. These wounds were inflicted by something sharp, deliberate, and designed to mimic folklore. Crime scene analysts testified that the spacing between the punctures matched no known tool or animal bite, while a metallurgist suggested the marks could have been made by custom-filed dental caps, a grisly affectation for someone playing the part. The defense, meanwhile, painted the accuser as a horror-obsessed fabulist, pointing to her social media posts about twilight rituals and a shelf of Anne Rice novels. But their case unraveled when investigators found photos on the defendant's phone showing him wearing elongated fake fangs at a nightclub just weeks before the attack. Worse yet, a search of his apartment turned up a journal detailing his transformation into a vampire, complete with sketches of bite techniques. Suddenly, the molds weren't just courtroom theater. They were chilling evidence of a defendant who'd weaponized his delusions. The jury's verdict was swift, guilty of aggravated assault, but the trial's legacy lingers in forensic circles where those dental molds are still occasionally cited in lectures about atypical wound analysis. And for legal scholars, the case raised a blood-red flag about how far courts should entertain a defendant's fantasy life when it spills into real-world violence. After all, if fake fangs can become exhibits, what's next? Werewolf claws, zombie scratch kits, the line between cosplay and criminal intent had never felt so razor-thin. The real bite of irony: years later, the defendant recounted his vampirism in a prison interview, admitting the persona was just a stupid gimmick to scare people. But for the woman he attacked, the scars, both physical and psychological, were anything but pretend. And in the end, that's what the jury remembered. Not whether monsters exist, but what happens when someone decides to play the part a little too well. The blueprints looked like something ripped from a science fiction movie, interlocking geometric shapes labeled with symbols that resembled no known alphabet, schematics for an engine that supposedly ran on cosmic resonance, and meticulous diagrams of a spacecraft's propulsion system with notes claiming it could fold space-time. These weren't the doodles of a hobbyist. They were the centerpiece of a 1999 intellectual property lawsuit that turned a Los Angeles courtroom into a debate over whether ideas from another world could be copyrighted on Earth. The plaintiff, an aerospace engineer named Dr. Elias Vance, filed suit against a defense contractor he accused of stealing his designs he insisted had been given to him during a series of alien abductions in the Nevada desert. What made this case extraordinary wasn't just the outlandish premise. It was the sheer complexity of the documents themselves. Vance's blueprints entered into evidence under seal, baffled even the court's technical experts. One propulsion diagram depicted a series of nested rings rotating in opposing directions, with calculations suggesting it could generate gravitational fields, a concept decades ahead of mainstream physics. The defense contractor's engineers admitted under oath that while the science was speculative, the math was internally consistent, raising the question: how could a mid-level engineer with no history of breakthrough research suddenly produce equations that stumped PhDs? Vance's testimony was even more surreal. He described being taken aboard a smooth, metallic disc where beings with elongated heads communicated telepathically, showing him holograms of technology that defied known engineering principles. His lawyer, a maverick intellectual property attorney, strategically avoided arguing whether the abduction was real. Instead, he framed the case around a simple legal principle: if Vance had fixed these ideas in tangible form, regardless of their origin, they qualified for copyright protection. The defense, meanwhile, countered that you can't copyright something that might belong to an entirely non-human civilization, quipping, "Unless the court plans to subpoena these extraterrestrial authors, this case is science fiction, not law." The turning point came when an independent physicist hired by the judge analyzed the blueprints and made a startling admission. While the technology was theoretically impossible with current human knowledge, the designs followed legitimate scientific principles, just ones far beyond our grasp. It's like Da Vinci sketching helicopters in the 1500s, he testified. The logic is sound even if the means don't exist yet. That ambiguity forced the court into uncharted legal territory. Could an idea be copyrighted if its true origin was unknowable? And if Vance's claims were dismissed as delusion, how did he produce equations that left experts scratching their heads? The judge's ruling was a masterstroke of pragmatism. He dismissed the case on procedural grounds, avoiding any ruling on the blueprint's origins, but leaving the door cracked for Vance to refile if he could prove independent creation through conventional means. The real bombshell, though, came years later when declassified Pentagon reports on UAP technology referenced theoretical propulsion systems eerily similar to Vance's diagrams, fueling conspiracy theories that his story wasn't so crazy after all. Today, the case remains a cult favorite among UFO researchers and legal scholars alike. It's a reminder that the law often lags behind the edges of human imagination, and that sometimes the strangest evidence isn't about proving what's real, but what happens when the unexplainable collides with the ink and paper world of intellectual property. After all, if a patent office one day receives an application stamped from Andromeda, we might finally get answers. Until then, those blueprints sit in a legal limbo as vast as the cosmos they allegedly came from. The photograph itself was grainy, slightly blurred, just like any other snapshot from a 1970s Polaroid, until the jury leaned in and saw the impossible. The man in the picture was unmistakably the deceased claimant, James McDowell, who'd reportedly died in a boating accident 6 months earlier. But here's where the courtroom froze. In the photo, his eyes were open. And not just open, tracking. As the image was projected onto the screen, multiple witnesses swore under oath that the corpse's pupils subtly shifted sideways, as if following someone moving past the casket. This wasn't just a surreal detail. It was the linchpin of a 1975 insurance fraud case that forced a federal judge to rule on whether a photograph could literally contain a ghost. The plaintiff, McDowell's business partner, had filed a massive life insurance claim, presenting the photo as evidence that McDowell's death had been faked, or worse, that he'd been murdered under supernatural circumstances. His argument was as brazen as it was bizarre. If the corpse in the photo was animate, then the body buried in the cemetery couldn't be McDowell's. The defense, representing the insurance company, brought in photography experts who dissected the image frame by frame. Their conclusion: the movement was either a trick of light and developing chemicals or deliberate double exposure. But then the plaintiff's team played their ace. They'd commissioned a forensic animator to enhance the footage, and the slow-motion playback seemed to show the eyelids twitch, an anomaly the experts couldn't immediately debunk. What made this case unforgettable wasn't just the eerie photo, it was the legal circus that followed. The defense called a neurologist to testify that post-mortem muscle spasms, while rare, could theoretically cause slight eye movements, but the plaintiff countered with a macabre piece of theater. They exhumed McDowell's body live in court, revealing a corpse with eyelids stitched shut, a mortuary standard. If the eyes in the photo were open and the buried corpses weren't, did that mean the photograph lied, or had something, or someone interfered with the body before burial? The courtroom devolved into arguments about rigor mortis timelines, mortician protocols, and whether the insurance company's own investigators had tampered with evidence. The judge's ruling was as pragmatic as it was unsettling. He dismissed the photo's supernatural implications but allowed it as evidence of potential tampering, ordering a deeper investigation into the death. The insurance payout was frozen indefinitely, and the photo itself vanished into a vault, though courtroom artists later admitted they'd refused to sketch it, calling it bad luck. The real kicker: years after the trial, a retired claims adjuster confessed the photo had been doctored not by the plaintiff, but by the insurance company's own experts who'd hoped to spook the jury into denying the claim. Their plan backfired spectacularly when the courtroom became convinced they were watching something far stranger than fraud, a corpse that refused to stay still even on film. Whether the movement was supernatural, scientific, or straight-up fakery, this case exposed a truth that still haunts legal circles today. When evidence bends the laws of nature, the justice system has to decide: is it proof of a crime or just a really good story? And sometimes the only thing scarier than a ghost in a photograph is the realization that someone, somewhere, thought faking one was a solid legal strategy. The probate court clerk had seen plenty of forged signatures in her career, but none quite like this. In 2001, a Missouri family feud spiraled into the legal stratosphere when one heir presented a will allegedly signed by their deceased grandmother 3 days after her funeral. The document's contents were shocking enough. It disinherited most of the family in favor of a pet parrot named Rutherford, but the real bombshell was the signature. The looping, unmistakable handwriting matched the grandmother's perfectly, down to the quirky little heart she always dotted her I's with, and according to the notary stamp on the bottom, it had been signed in the dead woman's own kitchen, witnessed by 2 neighbors who swore under oath they'd watched her hand glide across the paper like an invisible puppeteer was guiding it. What turned this from a grieving family's drama into a full-blown legal spectacle was the forensic evidence. Handwriting analysts brought in by the prosecution couldn't debunk it. The pen pressure, the flow, even the slight tremor in the letters matched samples from when the grandmother was alive. One expert famously told the courtroom, "If this is a forgery, it's the most flawless one I've seen in 40 years. The defense, representing the disinherited relatives, countered with grim pragmatism. Corpses don't sign legal documents, period. They hauled in the medical examiner, who reasserted that the woman had been clinically dead for 72 hours before the alleged signing, her fingers stiff with rigor mortis. Unless ghosts retain notary privileges, he quipped, this is either fraud or the first known case of post-mortem estate planning. The courtroom's turning point came when the family's housekeeper tearfully described what she'd seen the night of the signing. The will's beneficiary, the granddaughter who'd inherited everything, had allegedly held a séance in the grandmother's favorite chair, chanting as a pen moved across paper like something was pulling it. The prosecution pounced. This wasn't supernatural activity, it was old-fashioned string theory. They argued the granddaughter had rigged the pen with nearly invisible threads, using the séance as cover to forge the document. But then came the clincher, a time-stamped security video from the grandmother's hallway, showing the pen floating unaided for a full 12 seconds before dropping. The footage was grainy, dark, and utterly inconclusive, yet just unsettling enough to make jurors exchange nervous glances. In the end, the judge ruled the will invalid, not because he disproved its ghostly origins, but because Missouri law requires testators to be alive and competent at signing. The case's legacy, though, lingers in estate law seminars, where it's cited as the ultimate cautionary tale about dying without a clear will. As for the parrot Rutherford, he got the house anyway. The family settled out of court, reportedly terrified the grandmother might dictate another amendment from beyond. And somewhere in a vault in Jefferson City, there's still a probate file with a signature that defies all logic, a notary stamp dated after death, and a question nobody in that courtroom could answer. When the law demands proof of life, how do you argue with the dead? The real lesson here isn't about ghosts, it's about the gaps in our legal system when faced with the unexplainable. Because if a will can be challenged for being too perfect, what does that say about our obsession with airtight paperwork? Sometimes the strangest evidence isn't what breaks the rules, but what exposes how flimsy those rules really are when the impossible comes knocking. And in this case, it wasn't just knocking, it was signing its name in perfect cursive. The audio crackled to life in the hushed courtroom, filling the air with guttural chanting in a language no one recognized, followed by a bone-chilling command: "Rise and torment him." This wasn't a scene from a horror movie. It was a real 2010 harassment case where a terrified neighbor submitted recordings of late-night occult rituals as evidence of psychological warfare. The plaintiff, a retired schoolteacher named Marjorie, claimed the man next door had been blasting these sinister recordings through shared walls for months, accompanied by the stench of burning herbs and the sound of rattling chains. But this wasn't just about noise complaints. Marjorie's legal team argued the recordings crossed into criminal territory, deliberately weaponizing fear by simulating demonic summoning to intimidate her into moving out. What made this case so unsettling was the forensic analysis of the tapes. Audio experts testified that the recordings contained infrasound frequencies below human hearing that have been scientifically linked to feelings of unease and even hallucinations. The defense dismissed it as performance art, pointing out the defendant was a part-time voice actor who'd worked on low-budget horror films. But then the prosecution played a voicemail left on Marjorie's phone, the same eerie voice whispering, "The blood is yours now," in sync with hospital records showing she'd mysteriously fainted and cut her hand that same night. Suddenly, the courtroom wasn't just debating noise ordinances, it was grappling with whether sound itself could be assault. The legal turning point came when investigators uncovered the defendant's browser history, riddled with searches like "how to make someone think they're cursed" and "legal loopholes for scaring neighbors." His journal entries were even more damning, detailing a psychological experiment to exploit Marjorie's known fear of the occult. The defense's attempt to frame it as free speech, comparing the recordings to heavy metal lyrics, collapsed when the judge noted a critical distinction. Black Sabbath isn't targeted at specific individuals at 3 a.m. In the end, the defendant was convicted of harassment, setting a quiet precedent for cases where threats wear supernatural disguises, but the tapes left an indelible mark. Legal scholars still cite the case when debating where intimidation ends and art begins, especially when that art comes with a side of infrasound and the unmistakable suggestion that something unholy is on its way. Because in the American justice system, it doesn't matter if demons are real. What matters is whether someone's twisting belief in them into a weapon. And as that courtroom learned, sometimes the most terrifying evidence isn't what you see, but what you can't unhear. The diary entries read like something out of a historical novel, detailed accounts of cobblestone streets, gaslit parlors, and a life cut short by tuberculosis in 1894. The only catch, the author was a 7-year-old girl in 1975, and she insisted these weren't stories she'd imagined, but memories of her past life as a Victorian seamstress named Elena Whitmore. Fast forward to 1982, and those same childhood scribbles became the centerpiece of a probate battle so surreal. It forced a Boston judge to rule on whether reincarnation could legally prove family ties. The case began when the now adult woman, Lydia Hartley, came forward after the death of a reclusive millionaire named Charles Whitmore. She claimed to be his long-lost niece, not through conventional genealogy, but because her childhood diary proved she was the reincarnation of Whitmore's great-aunt Elena. The entries were unnervingly specific. Elena's favorite lavender sachets, the exact pattern of a missing heirloom brooch, even the names of servants who'd worked in the Whitmore household, details a child in the 1970s couldn't have known. Lydia's legal team didn't argue that the court had to accept reincarnation as fact. Instead, they framed the diary as circumstantial evidence of an inexplicable connection, one that merited DNA testing to confirm biological ties. The courtroom became a collision of spirituality and cold legal pragmatism. Forensic historians verified that many of Lydia's diary details matched real Whitmore family records, though critics pointed out some were vague enough to fit countless Victorian households. The defense, representing Whitmore's estate, brought in child psychologists who testified about cryptomnesia, a phenomenon where forgotten information resurfaces as memories. But then came the bombshell. Lydia correctly identified the location of a hidden compartment in a Whitmore family desk, a feature unknown even to the deceased's lawyers. The judge's ruling was a masterclass in legal sidestepping. He denied Lydia's inheritance claim, stating that even extraordinary personal beliefs couldn't override documented lineage, but he did order the estate to fund a DNA test. When the results showed no relation, Lydia's supporters cried foul, alleging the samples were tampered with. The case's legacy, though, isn't in the verdict. It's in the precedent it flirted with. How much weight should courts give to the unexplainable when it's the only thread connecting two lives? Years later, the diary resurfaced in an academic study on anomalous memory cases, its pages still sparking debates about whether the law's rigid frameworks can accommodate phenomena that defy them. Because when a child's crayon drawings include floor plans of houses they've never seen, signed with a name they shouldn't know, even the most skeptical juror might glance at the evidence and wonder. The partnership agreement looked like any standard corporate contract except for Clause 7, which stipulated that in the event of a verified zombie uprising, all company assets would immediately divert to fortifying a remote cabin in the Adirondacks. This wasn't a joke scribbled in the margins. It was the centerpiece of a 2015 breach of contract lawsuit that turned a dry corporate dispute into a legal deep dive on whether apocalypse prepping could ever be legally binding. The case began when one business partner accused the other of misusing funds to stockpile survival gear, bulletproof vests, cases of canned beans, and a suspiciously large order of crossbow bolts despite zero evidence of any impending undead threat. The defendant fired back, producing the signed agreement that explicitly allocated 15% of profits to zombie contingency preparations. What made this more than just a quirky footnote was the sheer specificity of the contract's language. It defined zombie using criteria ripped straight from horror films: reanimated corpses, transmission via bodily fluids, and loss of higher cognitive function with retention of motor skills. There were even subsections detailing how to confirm an outbreak, major news network coverage, CDC alerts, or direct visual confirmation by no fewer than 2 company officers. The courtroom's challenge wasn't just assessing financial misconduct. It had to grapple with whether a fantastical scenario, no matter how humorously framed, could create real legal obligations. The plaintiff's attorney argued the clause was metaphorical, a tongue-in-cheek way to discuss emergency preparedness, while the defense doubled down, calling it a valid risk mitigation strategy akin to cyber attack insurance. "You don't wait for the hurricane to buy plywood," his lawyer quipped. The turning point came when forensic accountants revealed the accused partner had quietly purchased the safe house cabin years earlier, suggesting the zombie clause might have been a smokescreen for embezzlement. Legal scholars still debate the case's implications. Could a vampire invasion clause be next? Alien colonization riders. The judge's ruling was pragmatic. The zombie provision was deemed unenforceable, but the underlying financial mismanagement wasn't. Yet the real legacy lies in the contract's eerie prescience. Drafted years before COVID, it included a line about viral vectors mutating beyond containment, a detail that made courtroom observers shift uncomfortably in their seats. Maybe the defendant wasn't just a paranoid survivalist. Maybe he was the only one who read the fine print on how quickly the world could unravel. In the end, the case became less about the undead and more about how we codify our deepest fears, whether in ink or in bunkers full of canned goods. Because when the law stares down the apocalypse, it turns out even zombies can't escape the cold scrutiny of a balance sheet. And somewhere in a vault in upstate New York, there's still a cabin locked and loaded, waiting for a threat that so far only exists in the fine print of a very strange contract. The property dispute seemed straightforward until the homeowner's insurance adjuster stepped into the backyard and found himself knee-deep in something far stranger than water damage or termite infestations. Scattered across the lawn were near-perfect rings of mushrooms, each circle measuring almost 12 feet in diameter, their caps glistening under the morning dew like some kind of otherworldly crop circle. But this wasn't just an oddity of nature. In a 2003 lawsuit that blurred the line between botany and folklore, a Maryland couple claimed these so-called fairy rings were physical proof that supernatural forces had damaged their home, and their insurance company was legally obligated to pay for it. Their argument hinged on centuries of European legend, where fairy rings were said to mark the dancing grounds of unseen creatures capable of warping reality. The couple's evidence. Time-stamped photos showing the rings appearing overnight, coinciding with a series of bizarre household malfunctions. Light bulbs exploding in sequence, faucets running red-brown water despite clean pipes, and a chilling, flute-like noise recorded by their baby monitor at 3:17 a.m. Each incident meticulously documented in a 3-ring binder labeled Fairy Activity Log. A mycologist brought in by the insurance company testified that fairy rings are a natural fungal growth pattern, but the homeowner's expert, a self-proclaimed folklore forensic consultant, accounted with aerial shots showing the rings formed a near-perfect pentagram around the property. "This isn't random," he insisted. "This is design." The legal showdown reached its peak when the couple's attorney played security footage of the largest ring glowing faintly at midnight, a phenomenon the defense's botanist dismissed as bioluminescent spores reacting to moisture. But then came the clincher. Soil samples from inside the rings tested positive for an unidentified mineral never before recorded in that region, with crystalline structures that, under a microscope, resembled tiny, intricate runes. The judge, facing a trial that felt more like a Grimm's fairy tale than a civil claim, made a Solomonic ruling. He dismissed the supernatural argument but allowed the soil anomaly as evidence of unexplained geological disruption, ordering the insurer to cover repairs, not because fairies were real, but because something had clearly altered the property in ways science couldn't yet explain. The case's legacy lingers in paranormal and legal circles alike. For skeptics, it was a cautionary tale about confirmation bias, how our brains can twist natural oddities into myths. For believers, it was a rare moment when folklore brushed against the cold machinery of the law, forcing it to acknowledge that not every mystery fits neatly into a spreadsheet. And for the insurance industry, let's just say acts of fairies still isn't a covered peril, but after this case, some adjusters keep a folklore field guide in their glove compartment just in case. Because when your job is assessing risk, sometimes the biggest danger isn't what you know but what you can't rule out. As for that glowing ring, it vanished after the trial, though the couple's dog still refuses to step foot in that corner of the yard. Coincidence, probably, but in the American justice system where evidence is king, sometimes the strangest testimony doesn't come from witnesses. It sprouts right out of the ground, daring you to call it a lie. The pitcher's mitt looked ordinary enough: well-worn leather, a few scuff marks, the faint imprint of a fastball seams. But in the summer of 1997, this unassuming piece of sports equipment became the center of a legal battle that left Major League Baseball questioning whether curses could be admissible in a contract dispute. The player at the heart of the controversy, relief pitcher Danny Lozano, had been on a career-high streak until he accepted a foul ball from a fan as a souvenir. Within weeks, his ERA skyrocketed, his fastball lost its bite, and he began blaming the ball itself, claiming it carried a hex from a disgruntled former teammate. By the time his agent filed a grievance against the team for forcing him to play with compromised equipment, the case had already become locker room legend. What made Lozano's claim so compelling wasn't just the sudden downturn in his performance, it was the eerie specificity of his accusations. He swore the ball felt unnaturally heavy in his hand, that it hissed audibly when he threw it, and that his shoulder ached after every pitch as if the ball itself were sapping his energy. Team psychologists dismissed it as superstition, but then Lozano's catcher came forward with a bizarre detail of his own. The ball's seams glowed faintly under UV light, forming what looked like tiny, intricate symbols. A retired umpire even testified that he'd seen the ball wobble mid-flight, like it was fighting the air, a claim backed by slow-motion footage that showed slight, irregular deviations in its trajectory. The league's response was equal parts skepticism and damage control. They brought in a physicist who demonstrated how atmospheric conditions could explain the ball's movement, while a materials expert insisted the glowing seams were just degraded stitching reacting to UV exposure. But Lozano's legal team had a wild-card witness, a Santeria priest who examined the ball and declared it crowned with hot feet, a ritual hex designed to bring misfortune to whoever held it. Suddenly, the case wasn't just about athletic performance. It was about whether an employer could be held liable for exposing a player to what he genuinely believed was supernatural sabotage. The arbitration panel's ruling was a masterpiece of bureaucratic sidestepping. They declined to rule on the ball's spiritual status, but agreed that Lozano's psychological distress over it constituted a valid workplace concern, ordering the team to provide a replacement ball and mandatory counseling. The cursed baseball itself vanished from the evidence locker shortly after the hearing, though rumors persist that it resurfaced years later in the glove of an opposing pitcher during a critical playoff game, one he lost after throwing a career-worst wild pitch. Beyond the locker room gossip, this case exposed a fascinating blind spot in sports contracts. Nowhere do the rules account for cursed memorabilia, haunted bases, or hexed jerseys. And while most athletes might laugh off the idea, Lozano's lawsuit proved one thing: when superstition and statistics collide, even the most data-driven organizations can't ignore the power of belief. Because in baseball, as in law, sometimes the most dangerous pitch isn't a fastball, it's the one nobody saw coming. The robbery suspect stood calmly in the courtroom, his demeanor more suited to a physics symposium than a criminal trial. His defense: he hadn't committed the crime, at least not yet. In a 2012 case that felt ripped from a sci-fi screenplay, the accused claimed his future self would eventually invent time travel technology capable of rewriting history, thereby erasing the charges against him. His evidence wasn't fingerprints or surveillance footage, but a handwritten notebook filled with complex equations and schematics for a device he called a temporal displacement modulator. The pages bristled with symbols that looked equal parts advanced calculus and alchemy, complete with sketches of a wrist-mounted contraption labeled retrocausal justice interface. What made this defense more than just a desperate Hail Mary was the defendant's eerie consistency. Under cross-examination, he didn't waver, explaining with unsettling calm that the robbery had occurred, but only in this current timeline. In 5 to 7 years, he assured the judge, my research will breach the Planck scale, allowing me to retroactively correct this judicial misunderstanding. The prosecution rolled their eyes, but the jury leaned forward when a physics professor from a local university, called as a reluctant defense witness, admitted under oath that while time travel remained theoretical, some of the equations in the notebook did resemble legitimate quantum mechanics principles. It's not entirely impossible, the professor conceded, just wildly improbable by several orders of magnitude. The turning point came when the defendant produced a plastic prototype of his temporal device, cobbled together from old calculator parts and what looked like a repurposed garage door opener. The judge, torn between laughter and fascination, allowed it into evidence not as proof of time travel, but as insight into the defendant's state of mind. Legal analysts later speculated this was a tactical error. By acknowledging the device at all, the court inadvertently lent a whiff of legitimacy to the argument, forcing the jury to grapple with a question no law school prepares you for. How do you weigh guilt when the accused insists it's only temporary? In the end, the jury convicted him, but the case's legacy outlived the sentence. Tech blogs jokingly monitored the defendant's release date for signs of breakthrough inventions, while legal scholars debated whether future exoneration could ever be a valid defense. Years later, when quantum computing advances made headlines, a few courtroom observers even dug up the old trial transcripts, half expecting to find a footnote where the verdict mysteriously changed. Spoiler, it didn't. But for one surreal week in that courtroom, the justice system got a glimpse of its own theoretical limits, where the burden of proof doesn't just stretch across space but time itself. And that's the real twist. Even if time travel were possible, the law might still be too slow to keep up. The defendant, for his part, served his sentence quietly. Though rumor has it he spent his prison library hours scribbling in that same notebook, adding a fresh page to the end. Appeal pending chronologically. Whether that's delusion, dedication, or a bet against the timeline, one thing's certain. In American courtrooms, the only thing stranger than the evidence is the imagination behind it. And sometimes the most compelling alibi isn't about where you were, but when you will be. The court transcripts read like a rejected X-Files script lab report stamped with phrases like non-standard nucleotide sequences and unidentified base pairs, expert witnesses debating whether a child could legally have an unknown biological contributor, and a bewildered judge peering over his glasses at a geneticist asking, "Are we seriously discussing extraterrestrial paternity?" This was the 2009 custody battle that made legal history, not because of celebrity drama or massive wealth, but because one parent insisted the other wasn't fully human. The case began routinely enough, a messy breakup, a child support dispute until the father demanded a paternity test. When the results came back, they didn't just exclude him as the biological parent. They included a chilling footnote. The child's DNA contained anomalous markers inconsistent with known human genetic variation. The lab, fearing contamination, reran the tests 3 times. Each iteration confirmed the same bizarre result. Approximately 7% of the child's genome didn't match any species in GenBank, the global repository of genetic data. The mother's attorney pounced, arguing this was proof the father had no legal obligations. The father's team countered with a theory straight out of a sci-fi thriller. If the unknown donor wasn't human, maybe the mother wasn't either. Suddenly, a simple custody fight morphed into a constitutional crisis. Can you establish parental rights if the other party's DNA defies classification? Does the legal definition of parent even account for non-human entities? The court brought in geneticists from Johns Hopkins who testified that while the anomalies were real, they could stem from ultra-rare mutations or undiscovered viral integration, not necessarily little green men. But then the father's legal team dropped a bombshell. Declassified Pentagon reports on biological UAP occupants describing similar genetic irregularities. The judge, now thoroughly out of his depth, ordered the anomalous sequences redacted from public records, fearing a media frenzy. What makes this case unforgettable isn't the verdict eventually. The father was ordered to pay support based on his assumed biological role, but the precedent it flirted with. For the first time, a US court quietly acknowledged that the building blocks of life, as defined by science, might not cover everything swimming in our gene pools. And somewhere in a sealed evidence locker, there's still a vial of saliva that challenges the very definition of human. Whether it's proof of alien ancestry or just a quirk of nature too strange for textbooks, one thing's clear. The legal system isn't equipped to handle paternity tests when the results come back not of this world. The real twist: years later, a biotech whistleblower claimed the alien DNA matched gene editing experiments from a black-budget lab in the 90s. But by then, the child had turned 18, the files were sealed, and the courtroom's existential question, what makes a parent when biology itself gets weird, faded into legal legend. Because in America, even the most earth-shattering evidence eventually gets buried under something far stronger: paperwork. The courtroom lights dimmed as the prosecutor pressed play on the VCR, revealing time-lapse footage that made the entire jury recoil in their seats. There, in grainy 1980s video, was the defendant's prized oil painting of a Victorian gentleman, its stern expression slowly twisting into a leering grin over the course of 6 hours. This wasn't CGI or clever editing. It was the smoking gun in a 1984 art forgery trial that forced a federal judge to rule on whether a portrait could literally come to life and, more importantly, whether its eerie transformations proved criminal intent. The case began when an elderly widow consigned her late husband's haunted heirloom to a prestigious New York gallery, only to have the appraiser declare it a worthless modern fake. But when she demanded its return, the gallery claimed the portrait had deteriorated beyond recognition, a suspicious explanation, given that their own security footage showed staff hauling it into a back room with tools. The widow's lawsuit seemed doomed until her grandson conducted an experiment. He set up a camera pointed at the painting for 3 straight days. The resulting footage showed the subject's eyes darkening, his lips curling, even his cravat appearing to flutter, changes no conservator could explain through normal pigment degradation. Forensic experts called by the prosecution were flummoxed. Infrared scans revealed no hidden mechanical devices, while chemists confirmed the paint contained nothing reactive enough to shift so dramatically. The defense, meanwhile, argued the footage proved nothing, maybe humidity warped the canvas or light played tricks on the camera. But then came the bombshell testimony from an art historian. The painting's alleged ghost, a 19th century railroad tycoon, had been notorious for swindling partners, and the gallery owner bore an uncanny resemblance to his great-great-grandson. The implication was staggering. Had the portrait's changes been a supernatural warning about history repeating itself? The judge, faced with evidence that defied both art science and basic physics, made a Solomonic ruling. He refused to entertain the paranormal angle, but found the gallery liable for fraud based on their suspicious handling of the piece. Yet the portrait's fate was stranger than fiction. After the trial, it vanished from a locked evidence room, leaving only a faint smear of paint on the wall where it had hung in the exact shape of a waving hand. Decades later, the case remains a favorite among both art detectives and ghost hunters, because whether the painting was truly haunted or just an elaborate con, it exposed a fascinating truth about evidence. Sometimes the most compelling proof isn't what you can explain, but what lingers unchallenged in the gaps. And in a legal system built on cold, hard facts, there's nothing more unsettling than a mystery that refuses to stay framed. The defense attorney's trial strategy binder seemed ordinary enough until prosecutors flipped it open during discovery and found pages of handwritten notes that looked more like a horoscope column than legal prep. Dated 1995, the documents detailed each potential juror's zodiac sign, along with scrawled astrological predictions like Taurus stubborn, unlikely to sway, and Gemini intellect over emotion, favorable for us. Suddenly, what should have been a standard drug trafficking case became a constitutional crisis when the prosecution filed a motion for mistrial, arguing their opponent had stacked the jury not through voir dire but by consulting the stars. What made this more than just an eccentric lawyer's quirk was the eerie precision of the selections. The impaneled jury consisted overwhelmingly of air and fire signs, Geminis, Leos, and Aquarians, while earth signs like Virgos and Capricorns, allegedly deemed too rigid by the notes, had been systematically struck. Even more damning, the defense had used all their peremptory challenges on jurors whose zodiac profiles the notes labeled high risk, while accepting those marked aligned with Mercury in retrograde. The judge, facing a precedent-setting dilemma, had to decide, was this clever strategy or unconstitutional jury tampering? legal scholars clashed over whether astrology could ever be a legitimate basis for jury selection. The defense argued it was no different than relying on demographics or body language, just another tool to assess bias. But prosecutors countered that allowing astrological profiling would open floodgates to pseudoscience in the courtroom. What's next? One quipped during arguments. Phrenology, palm reading. The debate reached its peak when a jury consultant testified that while astrology wasn't admissible as science, studies showed people believed their traits matched their signs, meaning the lawyer might have inadvertently tapped into real psychological biases. In the end, the judge declared a mistrial, not because astrology worked, but because the notes proved the defense had relied on criteria outside accepted legal standards. The case quietly reshaped voir dire practices nationwide, with many courts now explicitly warning attorneys against non-evidence-based selection methods. Yet the real legacy lies in the unanswered question: if a jury hand picked by the stars happens to convict, does that make the verdict written in the heavens or just in a very creative lawyer's notebook? The attorney, for his part, never apologized. Rumor has it he later represented a client in a copyright lawsuit against an astrology app, allegedly because it misrepresented Libra tendencies. Some legal strategies, it seems, are harder to shake than others. And in a system built on proof, sometimes the most controversial evidence isn't what's presented to the jury but what's used to pick them. From possessed dolls whispering threats to handwritten vampire hunting kits presented in probate court, the American legal system has seen evidence that would make even the most open-minded judge question reality. These bizarre exhibits aren't just courtroom curiosities, they're windows into the human psyche, revealing how deeply folklore, fear, and sheer creativity can infiltrate the halls of justice. Think about it: when a plaintiff submits a child's drawing of a past life as proof of inheritance rights, or a defendant blames their crime spree on a cursed baseball, they're not just testing the law's flexibility. They're exposing the raw, often messy intersection of belief and evidence, where logic shares the bench with the inexplicable. What ties these cases together isn't just their weirdness, it's the desperation behind them. Whether it's a grieving parent clutching at supernatural explanations or a scammer weaving elaborate myths to dodge accountability, these exhibits highlight how far people will go when the stakes are high. The haunted portrait that allegedly smirked at jurors, that wasn't just about art fraud, it was about a widow's fight to reclaim a piece of her history, no matter how eerie. The Bigfoot researcher who blamed vandalism on a Sasquatch beneath the absurdity was a genuine attempt to deflect blame onto the unknown. Even the most outlandish evidence often stems from very human emotions: fear, love, greed, or the need to make sense of the unexplainable. And let's not forget the legal system itself, which, to its credit, has repeatedly faced these challenges with a mix of pragmatism and bewilderment. Courts have ruled on cursed urns, time travel alibis, and alien DNA without ever officially endorsing the supernatural, walking a tightrope between respecting personal beliefs and upholding cold, hard facts. That's the real magic here, a system designed for fingerprints and contracts somehow making room for glowing mushroom rings and talking parrots, if only to dismiss them with a gavel's bang. So what's your take? Have you ever stumbled across a courtroom story that made you do a double take? Maybe a relative's bizarre will, or a local legend about a trial where the evidence defied explanation. Drop your favorites in the comments, because if there's one thing these cases prove, it's that the truth isn't just stranger than fiction. Sometimes it's stranger than we could ever invent. And who knows, maybe the next great legal oddity is lurking in your hometown, waiting for its moment in the spotlight. Until then, keep your eyes peeled and maybe check your attic for vampire hunting kits. You never know what might count as evidence someday.